Ladies and gentlemen, dear colleagues, first of all, I would like to thank the organizers for their invitation to participate in this important international conference here in adorable Budapest, with which we celebrate 7 decades of the European Convention on Human Rights. And I hope that you will enjoy my PowerPoint presentation. Due to the situation in Europe in recent years, attention today is increasingly focused on issues that place the court at the center of national, regional, and global public policies. My report is dealing with one such question. In the current development of the court's case law, 2 groups of cases related to the environment can be identified. The first, older group of cases, is related to environmental protection, that is the ecologically unsound operations and urban development causing pollution, illness or nuisance, and many other forms of environmental degradation. The second, new group of cases is related to climate change. A few general remarks apply to both one and the other group of cases. Firstly, we are talking about individual applications here. The role of interstate applications in these cases has yet to be examined. Secondly, it must not be forgotten that we are dealing with political matters. The protection of the environment and especially preventing climate change are not only human rights issues. Thirdly, it should be assumed that there will be no changes to the convention in the near future. We all know that Article 37 of the EU Charter of Fundamental Rights governs environmental protection. You can see it on the screen, Article 37. The Convention, as a much older instrument, does not have a similar provision. The Convention is simply not designed to protect the environment, and especially not to prevent climate change. At the end of September 2021, the Parliamentary Assembly of the Council of Europe presented a draft of the new additional protocol to the Convention, which would make the right to a safe, clean, healthy, and sustainable environment a new substantial Convention right. The proposed definition of that right is shown on the screen. However, judging by the 2022 recommendation of the Committee of Ministers, this new protocol of the Convention will not be adopted, at least not in the foreseeable future. Consequently, and this is also the fourth remark, everything is in the hands of the European Court. It depends only on the interpretation of the existing text of the Convention, whether it will get an autonomous green dimension or not. A lot has already been written about it, and an important high-level conference has been organized where it was discussed whether the Strasbourg Court should become the Europe's environmental and climate change court. Let's now look at the first group of cases. The court has been dealing substantively with this group of cases for almost 30 years. Ever since the 1994 case of Lopez Ostra against Spain. The court has so far ruled in nearly 300 cases concerning various forms of environmental risk and harm. It examines them primarily under Article 8 of the Convention. It has also developed a series of mechanisms of the so-called environmental democracy. However, the Convention contains a number of hurdles, mostly formal and procedural ones, but also substantive hurdles, which the court must somehow jump over if it wants to give an autonomous green dimension to Article 8. What path the court could take to jump over these hurdles can already be partially made out from the 2022 judgment in the case of Pavlov and others against Russia. It seems that this judgment went far beyond anything the court has decided so far in the field of environmental protection. At the heart of the dispute in the Pavlov case is a large and long-lasting industrial pollution that covers a city of 500,000 people. First, the Pavlov judgment indicates that the court could expand and start linking the concept of a victim under Article 34 to the concept of everyone referred to in Article 8. I would like to remind you that already in the 2019 case of Cordella and others against Italy, the court tried to take into account the impact of pollution on the entire community of all people concerned. Similarly, in the Pavlov judgment, it was expressly determined that, I cited, the industrial air pollution in Lipetsk has not been sufficiently curbed so as to prevent that the residents of the city, not applicants, the residents of the city be exposed to related health risks. This assertion must be linked to two more facts. First, none of the applicants lived in or next to the industrial zone as a source of pollution. They live very far. Second, it has not been established that this pollution has harmed the applicant's health. Thus, there is a noticeable departure from the previous regular requirement that there must be proximity between the place and the cause of pollution and the applicant. Second, the Pavlov judgment indicates that the requirements relating to the exhaustion of the domestic legal remedies could be modified. As you can see on the screen, the 15 applicants were absolved from the obligation to exhaust the domestic legal remedy. Absolved. Third, the Pavlov judgment seems to say the mere fact of exceeding the national permissible standards of air pollution in a large industrial city is sufficient to establish that the state in question violates its positive obligations to protect the right to respect the private life of its inhabitants. It seems for me that Judge Lobov could be right when he points out in his separate opinion that this is a significant expansion of the scope of positive obligations in Article 8 of the Convention. He said to somewhat unrealistic limits. To conclude with the first group of cases, there seems to be a real possibility that in the coming period, the court will begin to create more directly a kind of a sub-convention right to a safe, clean, healthy, and sustainable environment as an implied autonomous right that serves the realization of the right to respect for private and family life and home under Article 8 of the Convention. This right is of an instrumental nature, definitely only instrumental nature, would be exhausted almost exclusively in the positive obligations of the state. Let's move on to the second group of cases, which is related to climate change. Let me first present a few basic facts. There are currently 3 cases pending before the Grand Chamber on this issue. Generally speaking, all applicants were concerned with the consequences of global warming on their living conditions and their health. All applicants complained that the states have taken insufficient steps to prevent climate change, especially in the context of their obligations under the 2015 Paris Agreement on climate change. An oral hearing in Swiss and French cases was held in March 2023. The court also decided to adjourn its examination of 6 other cases on climate change until such time as the Grand Chamber has ruled in the 3 cases before it. It has also declared 2 cases from the United Kingdom inadmissible, and that's all. In all these cases, there are a number of open questions. For example, does the convention apply to the future generations? Does the state have obligation outside of its territory? How to determine the violation of the convention and distribute responsibility between several co-responsible states? How to determine just satisfaction in cases that resemble a kind of quasi-actio popularis, etc., etc. All these questions would require hyper-innovative interpretations of various aspects of Article 8 of the Convention if the Strasbourg Court decided to turn into some kind of Europe's climate change court. In any way, there is one certain fact. Extending the case law of the court concerning environmental protection onto climate change litigation might seem like stretching the already stretched case law even further, with the constant risk of exceeding the scope of the convention. Is it realistic to expect such a development of the convention supervisory system? This question cannot be answered in a straightforward manner. The convention system is truly unable to offer a holistic approach to what is a very complex, extensive, generalized, and widespread phenomenon such as a climate change, a monster. And, as I've already mentioned, the convention is simply not designed to protect the environment, let alone prevent climate change. This means that the court must necessarily hold on to an indirect and anthropocentric approach, any abandonment of that approach, anthropocentric, would mean exceeding the limits of the living instrument doctrine. And if that happened, it would damage the court's authority and legitimacy very hard, very hard. In this light, it is unlikely that the Strasbourg Court will ever become the climate change court. For the same reason that explain why no court can holistically deal with migration, we heard about it, terrorism, or war between states. Certain aspects of, or even only fragments on the mentioned complex and multidimensional social phenomena and legal issues can be partially translated into human rights law and fall under the jurisdiction of the Strasbourg Court, but never as a whole. Therefore, I see the indications of a Strasbourg green paradigm as the consequences of the fact that the convention supervisory system actually serves the applicants as a substitute for the missing climate change protection system. However, again, it should be made clear the court can cover some of the symptoms of climate change, but only to the extent that disputes related to climate change can be brought under the very narrow roof of the convention. I also see the indications of a Strasbourg green paradigm as a consequence of the fact that the court today, more than ever before, is faced with an obvious tension that is inherent to the whole European concept of human rights as one of the cornerstones of European identity. Jean-Max Sauvé, the former, very famous former vice president of the French Conseil d'État, gave an illustrative description of what it means. It is shown on the screen. Indeed, Europeans share a deep, common, two-sided conception of the person's human dignity and the general interests. So the most important legal mean for defending this European tradition is the constant balancing between these two ideas with the aim to bring them in balance, in harmony. However, I will be finished now. However, when it comes to global climate change issues, striking the right balance and at the same time not exceeding the scope of the convention, that is the real challenge. If not, mission impossible. Dear colleagues, thank you very much for your attention. Köszönöm szépen.